I'm gonna tase you. I'm gonna tase you, dude. Yeah, baby. Woo!
You may have seen in the news a federal jury in Michigan just awarded $4 million to a man who got his eyeball squished like a grape after being sucker punched by a police officer for no reason. Daniel Reiff was on his way to a roofing job. He and his coworker Ryan stopped at Ryan's house to get some tools. As they walked through the neighborhood, a neighbor got suspicious. She called the police on a non-emergency number, reporting that she didn't recognize the two younger-looking kids who were walking through her neighborhood. The Clinton Township police apparently didn't have much going on that day, so they sent the cavalry, 8 police cruisers in total, who scrambled to the scene, even speeding and weaving through oncoming traffic, as if they were heading to a bank robbery. Now, when Daniel saw this, having had prior bad experiences with law enforcement, he left Ryan's house and he headed towards his bus stop. But then Officer Broc Setty spotted him. He got out of his police car and he chased him down.
I'm gonna tase you. I'm gonna tase you, dude. Yeah, baby. Woo!
Whooping a battle cry as if he was a Viking about to murder some monks. And actually, Officer Setty wasn't all that far off. When he caught up to Daniel, he sucker punched him in the face, which ended up squishing Daniel's eyeball like a grape, permanently blinding him. So now I'm going to introduce you to the civil rights lawyer who represented Daniel in that trial.
The officer took one of his hands, put it on our guy, pulled him, and then punched with his other hand.
And he's going to tell you all the juicy details. I'm sorry, did you say that you brought a grape into the courtroom?
So we got like a big juicy grape. You know, not a small one, not like a wine grape that you see, but like one of the big, juiciest grapes at Kroger. Boom.
What I thought I would ask you, if you don't mind, is I assume that you remember what you came out with to this jury, and it obviously turned out well. Like, what was the sort of opening phrase, like the opening paragraph or so, that you said to this jury when the judge asked you to stand up and begin your opening?
I didn't want to focus on him, what he did, because it was, they had a lot they wanted to victimize him. So the focus was on what the police officer did. Look, we trust and we love our police officers, but they have to follow certain rules. Those rules protect them and they protect the community. They protect all of us. And the police officer in this case, he violated the rules. He got angry and he sucker punched someone in the face when he didn't need to, and he caused catastrophic and permanent injuries to them. There was a call. It wasn't to 911. A neighbor called the non-emergency line, right? So she had to go in her phone book or her website, look up, hey, what is my local police station's non-emergency number? Because she didn't want to call 911. And she called that there was 2 kids who were cutting through yards. And she said, I don't know what they're doing. It could be suspicious. So the response from the police, and she said, look, I want somebody to drive by and just kind of do some community policing, just see what's going on, right? And this lady testified in our case because she felt horrible about what happened. So the police send, Clinton Township Police Department sends 8 cars. So there must have not been a lot going on that day. They send 8 cars or 8 officers, and we have footage right from the beginning. They're amped up and looking for a beat, right? So they drive into oncoming traffic to chase and find our client, which was completely unnecessary and endangered people driving down the street. I mean, to have all these police cars zipping in oncoming traffic head on, making turns for a report of some kids going through a yard.
7-6 out of that way.
Okay. Blue hoodie just hopped my fence and that fence.
Okay, he's going that way?
Yep.
Okay. Citizen said it's going northbound from Ingleside.
Where is your client when Officer Setty first sees him?
So our client gets off a bus. He's going to a job site to do some work, and he cuts through a yard. Okay. And when the officer arrives, he sees him walking down the street. There's no sidewalks in this particular area. So you kind of have to walk on the side of the street, and he's just walking down the street, right? And the police officer tries to starts like aggressively, like, stop.
Come here. Come here.
We want to talk to you. And our guy, who's had some not so pleasant experiences with the police in the past, who hadn't done anything wrong at this point, who didn't have any illegal items on him or anything, but had some negative experiences with the police, said, I don't want to talk to you. I didn't do anything. He just got off of the bus. And so he walked away. That's when the officers started to like go on this like rampage to go and try to arrest him, apparently, or detain him. And then he took off running at that point.
I'm gonna tase you, dude. Yeah, baby. Woo! Come here.
Then the defendant officer.
And what's his name?
Broc Setty.
Broc Setty.
Broc Setty.
And it's the Clinton Township Police Department?
Yeah, here in Macomb County, Michigan.
At the time that he takes off running, has any crime even been reported to the officer?
No, the only thing that was reported was there was 2 kids in the neighborhood walking through backyards. That was it. They didn't know if our guy was that guy or not. They suspected that he was one of the 2 kids that was walking through backyards.
So
right?
Do you believe there was any reasonable suspicion to detain your client in the first place?
Absolutely not. I mean, there was no crime. There was no reasonable suspicion. And even if there was reasonable suspicion, it was so minor. It wasn't, hey, somebody's breaking into houses. It wasn't, there's been burglaries in the neighborhood. It was 2 kids are walking through a backyard on a non-emergency line, right?
The thing that stood out to me with the body cam is how excited this officer was that somebody was running from him. He was celebrating as he's closing in on him.
I'm gonna tase you, dude. Yeah, baby. Woo!
Yeah, he was excited. It was like a mall cop, right? You ever see like a mall cop gone haywire? It's like they're bored at the mall. I was just at the mall with my family, right? They're like walking around. They're seeing everybody doing all this nice shopping. They don't look that happy. It's like they're like waiting for like an opportunity to like go do something. And that's exactly, this was a mall cop syndrome, all right? Not there's anything wrong with mall cops out there, but this guy was excited to be able to basically use force, excited to be able to attack our guy. It wasn't just a punch, it was a sucker punch. I think that there's a lot of meaning in that word. When somebody hears that somebody gets sucker punched, I think the word sucker punch, it's like by surprise, kind of a cheap shot, dishonest. It has those connotations. That's what he did.
All right, I'm done. Turn around now. Turn around. I'm done. Get on your stomach now. Get on your stomach. I'm gonna punch you. Get on your stomach now. Get on your stomach. Get on your stomach. Shit ton of drugs. Get on your stomach now. Get on your stomach now. What the did I say? Give me cuffs. Put your hand behind your back. Give me cuffs.
Please help me up. Please, God, help me up. Please. Please, I can't breathe.
Relax.
Cuff me, please. Give me a second to breathe, please. I'm anxiety.
So it looks like he's running after him and they get to a fence and your client's on the other side of the fence. Where in relation to that did the punch take place?
So our client ran over the fence. He fell down, and then the officer was in close pursuit. And then right after that, just ran up to him, grabbed him, punched him.
Did the punch take place after the officer crosses the fence as well?
Yeah.
Because he kind of grabs him on the other side of the fence, right? And then the officer jumps over the fence. And it was then that he punched him.
Yeah. So, this was a calculated sucker punch. I think because our Daniel was on a lower spot, right? So he's down, and he's just kind of like turned to look like this. I mean, it was the worst possible angle. That's why you're not supposed to use that type of strike. You're supposed to use like an open hand strike, or, you know, the legs, the ribs. No force was really necessary here. Our guy had given up. He had said, you know, okay. So, I mean, the force was just gratuitous.
21980. Alright, take meds, sir.
3 grams of heroin?
Yes, we need an ambulance, please.
Well, then you know what? Chill out.
Okay. Oh, God. I don't want to die.
Well, you shouldn't have ate the heroin.
I didn't know what to do.
How about you stop and confess up to it? Now you got fleeing and loot charges on you. You got resisting obstruct.
What was the deal with the heroin? Listening to the body cam, there's a discussion like he swallowed, you know, saying that it sounds like he's saying he swallowed heroin.
Yeah.
And he's worried he's going to die.
Yeah. So, you know, I didn't know this, but apparently if you tell a police officer that you've ingested drugs, rather than taking you to jail, they'll take you to the hospital. And so I don't know why Daniel said that. It wasn't true. He didn't have any drugs on him. His tox screen was clean. So Daniel said, hey, I did this. He was scared to go to jail. I don't know why. So he said that, and, you know, I don't know why. That he's just scared.
Was there ever a subsequent blood test that determined whether or not he had swallowed any heroin?
Yeah, there was no drugs in his system. So
Interesting.
you know, he was just scared. He's a scared guy.
I mean, why wouldn't you be scared? I mean, you see stuff like this, and I mean, it's like, well, why did he run? Well, why wouldn't anyone run? I mean, you know, clearly he's got like this crazy person chasing after him who means harm for him.
I'm gonna tase you, dude. Yeah, baby. Woo!
Now, what kind of injuries? I saw in the media report they used the phrase squish like a grape, I think it was. Is that a phrase that you were allowed to use in the trial?
Because we brought a grape. We used a grape to show. Boom. And that wasn't my words. That was one of the treating doctor's words. So the doctors were amazing. Most of the doctors that testified were treating physicians. The eye doctors were amazing. You know, they testified that in order to explode somebody's eye like they did, and they said that it was like a grape, and they, you know, boom, a grape getting hit, or if you put it between your fingers and you pinch it and it kind of explodes, or like a cherry tomato. That's what happened to this guy's eye. And they're like, do you know how much force you have to put on the eyeball? Because you can get hit with a baseball in the eye. You know, you can get it punched in the eye. You get black eye. I mean, our eyes are kind of recessed. They're pretty versatile. I mean, you can hurt them, but they usually don't explode. He testified 250 pounds per square inch of force had to be applied to his eye. The way that he was hit, where our client was kind of in a down position, where the officer was able to sucker punch with full force coming down. It was just like the most powerful type of strike that could be done, and it was directly on his eye.
I'm sorry, did you say that you brought a grape into the courtroom?
Yeah, we had a grape. We used it in closing, cross-examinations. It was just a grape. Kept it up at the podium.
Now, did defense counsel try to stop you from doing that?
No, I mean, because the doctor said it was like a grape, right? And it was a demonstrative. So we got like a big, juicy grape. You know, not a small one, not like a wine grape that you see, but like one of the big, juiciest grapes at Kroger. And we brought it in and we put it there as a reminder because that's what the doctor said. It blew out his orbital as well. So, you know, his orbital, he had fractures there. And then it blew out his teeth. Not all of his teeth, but he had some teeth knocked out. So, I mean, that is a tremendous amount of force. It's like almost like a baseball bat.
Okay, please don't let me die.
You're good. Just relax, dude.
Please don't let me die. I'm trying.
Where'd the green and gray jacket?
He ditched it.
Oh, he did? Okay.
You good? You need anything right now?
No, I'm good for now.
7-6 dispatch. You got men starting on you, right?
You're cut?
Yes, they're on the way.
What's your name, man? What's your name?
What?
What is it?
James.
You got ID on you?
Okay.
Just in some of the comments I saw to the media report, like a lot of the questions were, why did he run? Did your client testify at the trial?
No. And that was a tactical decision that we made. And why did he run? That's a great question. And it's easy to look back in hindsight. And that was one of our fears is, a bad juror could say, well, look, yeah, this happened to this guy, but it wouldn't have happened if he didn't run, but the force has to be proportional. I always use with the jury, like, if a little kid steals a pack of bubble gum and is trying to rob a store, the officer can't shoot the kid in the back. I mean, even though the kid shouldn't have took the bubble gum, that's wrong. That's illegal. And you have to understand our client who had a difficult upbringing. He struggled with substance abuse addiction. He had very negative encounters with the police. He was scared of the police. He didn't want to be around the police. And he hadn't done anything wrong. And he was walking down the street when all these officers roll up on him in a very quick, escalating type maneuver and scenario, and he just got spooked and he started to walk away. So he didn't just like see the cops, turn around and book it. He saw the police officers. They came on him with kind of a show of force of a lot, and he just walked past them and walked in the other direction. And then they start driving into oncoming traffic, start going lights and sirens, start escalating, and then he just got spooked and he ran.
If you're running and there's somebody chasing after you, like whooping like that, like of course you're going to run faster. I mean, it's like, I've never heard, I don't think I've ever heard anything like that in all the thousands of these videos that I've watched.
It was like a barbarian war cry, or like, I don't know if you remember, if your viewers are old enough to remember, but there was like a nominee for president, Howard Dean, and like he was on the campaign trail and he like did this like whoop and then like
ended his political career. Yeah.
He ended it. It was over. It's like, we can't have that guy as president. He's whooping.
We're going to South Carolina and Oklahoma and Arizona and North Dakota and New Mexico. And we're going to California and Texas and New York. And we're going to South Dakota and Oregon and Washington and Michigan. And then we're going to Washington, D.C. to take back the White House. Yeah!
I'm gonna tase you, dude. Yeah, baby. Woo!
Our use of force expert, who was great, who was a former SWAT officer from LA, who'd been shot in the face doing gang duty and things. And, he's like, look, this was handled the wrong way from Jump Street, because everything that the police did in this situation escalated the situation rather than de-escalated. And a good police officer shouldn't want to escalate things so they can use force. A good police officer should try and de-escalate if possible. And so everything here escalated, sending 8 cops and all these massive cars, lights and sirens, and then driving into oncoming traffic at high speeds, running after this guy in an aggressive way, whooping and screaming at him in some type of like war cry to somebody who's terrified, screaming like, I'm gonna tase you, like, woo, let's go, let's go, I'm gonna get you. It's like me chasing after my little kid in the house, like, I'm gonna get you, but it's not fun. It's not fun in the real world.
Did the officer testify as to what his purported justification was for the punch?
Yeah, so the officers admitted that he wasn't in fear for his safety, which was clear from the video. I mean, he was kind of excited to be able to do this. The justification was our client was not submitting, and it was the famous resisting. It was kind of ambiguous how our client was resisting because he was literally on the ground.
May have. I don't know. I know when I jumped here, he got caught, and I ended up grabbing his collar, and he tried to pull it away, and then I just held on to him, and he fell down. So that could have been from the fence. Yeah. He wasn't getting on his stomach either.
The officer said that he tried to do a strike to the body and missed because he blamed our client, said that our client basically moved into his punch, which caused him to sucker punch the face. The video is kind of poor quality and at the time of the punch, so we slowed it down and we showed the jury frames. And if you frame it out, you can actually see what happened was the officer took one of his hands, put it on our guy, pulled him, and then punched with his other hand. So the video did not support the officer's story about why he used force, which was, I was trying to subdue a resisting suspect and I tried to do a rib punch, because our use of force expert testified and his officers know you should not be using a full force sucker punch at somebody right in their face, right in their eyeball.
Get to the drugs.
Get on your stomach now!
Because that's considered deadly force. And you can maim, disfigure, kill somebody like happened here. But the officer's story, justification for the force, didn't match the video, and it defied common sense.
Chicken like starts blinking and it's dogging out on it. And I'm like, well, you back off the gas, the light goes out, you give the gas and the light comes on.
Hi.
Hi. Well, we're going to see if he can walk. If not, we'll have to do the stretcher.
Okay, I wasn't sure if they would just sit there. Are they like...
He said he took some heroin. He swallowed a bunch of heroin before he ran from us.
That's what my notes said. But is he like with it? Like conscious?
Nah, he ran for a little bit. You're okay.
Is he his eyes?
Trying to climb over in here?
Yeah, he ran all the way from the other side of Metro, all the way this way.
Oh, no shit.
Yeah, we got a call of him run through backyards, and then we went to stop him. He took off running.
So he come from...
Yeah, this way. We don't. He didn't. I was right behind him the whole way from Drexel all the way over, and he didn't toss anything, so he shouldn't expect to find anything in our yard.
Heard the yelling.
All right, that's enough excitement for the morning. Take care, sir.
He told us James.
Is there any way that we can like talk to him like in the I just need you and I.
Yeah, that's fine.
Before we buckle. Get a barrier sheet. Hey, listen. Sir, it's me. It's not the cop. Listen, I'm trying to tell you something. Your eye is hurt, and your eye, it actually looks really bad now that you're opening it.
We're
Are
going to
you
go,
having pain?
hey Tony, we're going to go right
Yeah,
side.
you look pretty,
Right
his
side.
eye is, did you see it? I mean, it's,
Yeah.
it looks like he's going to need like an ophthalmology consult. Yeah, there's that.
Here, sit up.
Honey, I want to get you, I want to get an IV on you and get you going, okay? So, it's just more a matter of you got a really serious
Roll him a little
injury
more.
to your eye, okay?
Gotta let go of your hand.
Can you hear me? Yeah. When you said that you swallowed heroin, how much did you swallow?
You want both hands to be?
Here, he can roll back.
Okay, lay back, honey. Your hand is. We're gonna try to get you. Let's go up. Oops. Slide you up, honey.
Was this a large police officer?
Yeah, he's a big dude.
Do you know whether he received any discipline from his department?
No, he was promoted.
Of course he was.
So he was promoted to, I believe he was a sergeant at the time of trial. So, which is another reason why this verdict's so important, because there'd be no repercussions. I mean, that was one of the themes is, you police the police, ladies and gentlemen of the jury, because there's nobody left. Our founders entrusted you. They didn't say judges. They don't trust lawyers. They don't trust the chief of police to do this. You're the guardians of the Constitution. You have to police the police. That's why we're in federal court, and that's why your verdict's so important. And, the attention that it got, I think, is important because it sends a message to Clinton Township and other police agencies in Michigan and all over the place that, this is just unacceptable. We were happy to see the verdict. The worst part, I think, about the case was how the defense counsel victim shamed our client. They suggested that we couldn't prove that his injuries, including his eyeball being blown up, was from the punch. They said, we don't know. Maybe he did it when he fell, which is absurd. All the medical doctors laughed. I mean, they said, that's impossible. This was through a high force punch to the face. It would not have done this. You wouldn't have had the damage going here down like that. And you can see on the video, I mean, he's not like, oh my God, my eyeball exploded as he jumped over the fence or anything. So I thought that was offensive. There was no accountability, no acceptance of responsibility. And then the victim shaming. We knew that our guy, as often in civil rights cases, I mean, we never have perfect clients. I'm not a perfect person. I don't think anybody is. But we know that in civil rights cases, a lot of times we're dealing with marginalized people, people that might have criminal histories that maybe are scared of the police. That's why they run, things of that nature. Our guy had struggled with, Daniel had struggled with addiction, and we waived economics as it related to wages. I said, look, we're not going to claim that, he can't work, because his work history was pretty spotty. He'd pick up odd jobs, do things around. So we tried to be honest with the jury about about who he was.
All right, man. Yeah. Well, I know you're busy. I'll let you get back to work, but I appreciate you giving me, sort of the insight to this. And
yeah, thank you. It was really great. I really love what you're doing. We need to bring more attention to these. These are always tough cases, and you gotta. It's a hard road. It's been a hard road for Daniel. It's been a hard road for a lot of our clients, because these things take forever, and then they say that what happened to you isn't worth much. This is what I hear on all the civil rights cases. It's not worth that much, or you deserved it. So I appreciate you have a great show, and thanks for having me on, man.
So the only thing we haven't already covered is the underlying law about why this was a civil rights violation. This was an excessive force case, which is a violation of the Fourth Amendment, the right to be free from your government using excessive force against you. The standard that the federal courts use to determine whether or not a police officer used an excessive amount of force are called the Graham factors. 3 factors. 1, the severity of the crime at issue. 2, whether there is an immediate safety threat to anyone. And 3rd, whether the suspect is actively resisting or fleeing. Prior to the jury trial here, the trial judge looked at all of the evidence in the case and decided that the case would go to the jury and that qualified immunity would be deprived of Officer Setty. In so doing, the court analyzed the Graham factors as applied to this case. Regard to factor 1, the court found that when the police were initially called, Reiff had committed no crime at all, and Officer Setty had no reason to believe otherwise. Regarding Factor 2, the court found that Officer Setty, by his own admission, had no reason to believe that Reiff was armed, and at no point during the interaction did Reiff hit, yell at, or threaten Officer Setty. Regarding the third factor, the court found that the video footage itself showed that Reiff's alleged non-compliance was not paired with any signs of verbal hostility or physical resistance, and therefore cannot be deemed active resistance. In short, all three of the grand factors weighed in favor of Mr. Reiff and against Officer Setty, and thus a finding that excessive force was used here, or at least giving the jury the opportunity to make that determination and potentially award damages, which they obviously did. And I pulled a bunch of those court documents, which I will post at the blog and link below, including the complaint from the lawsuit, the court's opinion that I just cited, the actual jury instructions that were used in the trial, and the actual verdict form, all posted to the blog, linked in the description below. And thanks again to Attorney John Marco for joining me here. And if you want to contact him, I will link his contact information also in the description below. And I might as well also link the Clinton Township's information below as well if these are your public servants and you want to completely change them out. I wouldn't blame you at all. It's just insane that there was no discipline of this police officer who committed this violent act and cost the taxpayers $4 million. Not only did they not discipline, but they promoted him. Just absolutely insane. So even if these are not your public servants and you want to help those poor suckers who live in Clinton Township, you can help by watching this footage, by sharing this footage, by liking and commenting on it, which gets the algorithm going and helps the footage go viral. That in turn just sadly gets results. And if a $4 million lawsuit doesn't get results, that just goes to show that it's insane that YouTube videos can get more results, more accountability than even wildly successful lawsuits. If I hear anything else, I'll do an update, and you can follow along by subscribing both here and at the blog at thecivilrightslawyer.com. You can follow me on X at JohnBryanESQ. Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.